As quoted last week in USA Today, many businesses concerned about liability issues in the face of new laws and the impact of distraction-related crashes on their bottom line are beginning to develop policies for their fleet drivers. Our next panel will present an overview of current best practices for corporate policy on the use of electronic devices in motor vehicles and the liability for their employees in distracted driving. We will also hear of emerging technologies coming into the car and solutions that are currently available to mitigate these distractions. First, we will hear from attorney Todd Clement from the Clement firm in Dallas, Texas. Todd has successfully represented victims of catastrophic injuries and wrongful death, primarily in the areas of trucking and commercial vehicle collisions. He's received numerous accolades, including D Magazine's 2009, 2011, and 2012 Best Dallas Personal Injury Lawyer, and D Magazine's 2009, 2010, and 2011 Texas Super Lawyer. And he's one of the top 100 Texas trial lawyers by the National Trial Lawyers.
Thank you, ladies and gentlemen. I believe there is an officer in the room. There's a couple of them because I want to report a theft. Joel and Paul stole a lot of my material, and I want them prosecuted immediately. And it's really interesting because I've spoken with Dave Strayer, who is one of Joel's colleagues, but I've never spoken with either one of these gentlemen, and yet a lot of our conclusions have been the same, but we're coming at it from different directions. So one of the things that I thought was most interesting was the question of, okay, there's the disconnect between knowing the behavior's bad and yet not doing the right thing. Well, my perspective is, from a business standpoint and talking to businesses, is I'm going to show you what's going to happen if you don't do the right thing. And in fact, one of the titles of my speech over the years has been Cell Phones and Driving, Bad for Business. Now, the title of this particular talk, though, is DWD, Driving While Distracted, the new DWI. And you guys have heard a lot about that term DWI equating back to DWD, and we're going to talk about that a lot today. But I guess the first thing we want to talk about is why change the behavior, because that's the number one question. We know the behavior's bad, why change it? Well, I think you go back to the civil lawsuits and you say, over the years, oftentimes the civil law system has been an agent for change. It has forced corporate America to do the right thing when it otherwise did not want it to do it. And what generally drives this change are large jury verdicts. When I first became a lawyer back 25 years ago, we used to think that jury verdicts were driven by sympathy and by outrage, because that's what we thought motivated jurors. But there's been a great deal of psychological studies in the last 10 years that say that that's not the case. That instead, jury verdicts are very large jury verdicts come from jurors being motivated by the more primitive parts of our brain. The primitive parts that indeed value self-preservation and preservation of the species, particularly the young, the highest. And let's think about it. We all know that that's instinctively true. Who among us here would not very much be willing to give up our lives to protect our young from extreme danger? And that's indeed the position that we're in. However, let's examine the most common argument that defendants use against cell phone use. And we all know, and we've heard it before, everybody does it. How can our company be condemned or found legally liable for something everyone, including the vast majority of the jurors, do themselves? Well, ladies and gentlemen, if you're on the corporate side, let me give you the answer to that. And everybody here knows it's the truth. Cell phone use is the one activity that most people want to do themselves, but which they desperately want others to stop. Now, we're going to play lawyer and jury right now. At the beginning of a trial, we have what's called Voire, and that's the time that I get to ask you guys questions and you get to give me back feedback to find out who my best jurors might be and who I don't want on my jury. And I'm going to ask y'all to participate by raising your hands, and these would be sample questions I might ask in a jury trial. Raise your hand. How many of you have seen someone drive dangerously while using your cell phone? Raise your hand. Oh, wow. How many of you have feared for your safety because someone around you was using their cell phone while they drove? Oh, okay. It looks like everybody. How many of you believe cell phone use while driving should be banned? Yeah, little peer pressure here, but it looks like most of you. How many of you think it's extremely dangerous to text or write or read a text or email while you drive? How many of you believe texting while driving should be banned? How many of you do all these things or some of these things yourselves? That's the disconnect, ladies and gentlemen. That's the disconnect. But I've never seen a more fertile ground than the argument in favor of self-preservation and protecting the community than through a large cell phone verdict. The jurors will think by rendering a large verdict, they can motivate others, not themselves, others to be safer and prevent other drivers from doing the one thing that they perceive threaten themselves and their children the most as they drive down the road every single day. So, you've seen this. Driving while distracted, the new DWI. You know, there was a time before Madden, you've heard it many times today, when drinking and driving didn't have the stigma and the jury poison that it has today. And I firmly believe that until we create smart cars that drive themselves and protect us from our own recklessness, DWD, driving while distracted, will be the new DWI of the 20th century. In fact, studies by Dr. David Strayer told us that indeed driving while distracted, driving while talking on your cell phone is equally as risky as driving while intoxicated. Now, everybody in here that's in business, think about this question. There's a few little nuggets here that I hope will come through. Can you imagine how a jury would react if they knew a company regularly knew about and even encouraged and profited from their employees driving while intoxicated? As a practical matter, that's what an employer is doing every single day when it has not banned its driver's cell phone use while on the job. Now, let me educate you just a little bit as to what will happen if your company is involved in a case that has cell phone use involved. What's going to happen at the very beginning of the case, if you have a competent lawyer on the other side, they're going to immediately start trying to drill they're going to dig for cell phone gold. They're going to start what we call the discovery process. And through the discovery process, in every single case, I get the opposing driver's cell phone records. And everybody thinks, oh, big deal. All you're going to get is that little printout that I get at the end of the month. That's not the case. I get something called cell tower records that can show that a phone call began in Dallas and ended in Fort Worth, and it can prove that you were on the road and that you have a regular pattern of practice of driving while talking on your cell phone. With some carriers, I can even get text that are exchanged between drivers. So we can get a ton of records that show a pattern of practice of DWD. Well, not only that, and Dan will talk to you about this a little bit, there is something out there called telematics, and I won't steal his thunder on that like Joel and Paul did on me. I will let him talk about telematics and tell you that is another can of worms that a business opens up, because you can compare the telematics records with the cell phone records and get a real picture for what that driver's doing. I think the single most important impact, though, of cell phone use on a case is generally when there's a tragic accident, we know who was at fault for the accident itself most of the time. Somebody rear-ended somebody went on the wrong side of the road, somebody ran a stop sign, somebody ran a red light. So the defendant's already liable and the employer's already liable, but I believe that cell phone use is essentially gasoline on a fire. It will make that bad lawsuit that harms your company much, much worse. Now, if negligence is not a given, and it's a swearing match, one driver says it's his fault, one driver says it's his fault, then if there's cell phone use involved, who do you think the jury is going to believe is at fault? So you lose either way. There's another aspect of this that you need to be aware of, and that's the aspect of gross negligence and punitive damages. I believe that is one of the biggest worries that a business needs to have in connection with cell phone use, because gross negligence is essentially proceeding with conscious indifference in the face of an extreme degree of risk. Y'all set through this morning some incredible programs, incredible victim impact statements. Is there anyone here that doesn't believe that talking on your cell phone while driving, and particularly texting while driving, does not involve an extreme degree of risk? You as a business have that knowledge, and if you do not have a meaningful policy in response to that, I believe it can be gross negligence, and it can have the award of punitive damages involved. So, the next question essentially is, what are you going to do about it? Some businesses says, we'll just have enough insurance to cover us. Well, USAA will tell you, number one, you may not have enough insurance to cover you, because if you have a explosive jury verdict, you may not have enough insurance. You may also be aware that in Texas, a lot of times, in certain cases, punitive damages are not insurable. So even though you've got all that wonderful insurance, it won't even apply, and indeed your company's assets are exposed to this loss. And the third thing, and USAA, I'm sorry, because quite honestly, I do believe that you are truly, and I'm not saying that because you're hosting this, you're truly the finest insurance company that I've dealt with in the last 25 years. But insurance is the one thing that if God forbid you ever have to use, it costs you a fortune in the future. And that's what will happen if indeed you're involved in a catastrophic injury. Your insurance rates, you will be paying for it for a very, very long time. So, sorry. Don't want to do that just yet. I didn't tell you about the most important tool that we as plaintiffs' lawyers have when we get one of these tragic cases. And that tool is the deposition process, the process by which I'm allowed to ask questions to the company from beginning to end and to find out truly what was going on the other side. And I want to talk to you about the deposition process and provide you indeed with an illustration of what can happen. But first, to personalize this loss, I want to tell you a story first. And it's the story of the Ragsdale family and the Woodson family. And we're very fortunate today to have two members of that family here with us. We have Becky and we have Mindy Woodson with us. They're very courageous to be here. Because on the morning of January 25th, 2010, Mindy was driving their passenger vehicle with her grandmother, Peggy, in the front seat, and they were stopped dead in the highway on Highway 82 between Sherman and Bonham. And it's a major highway. It's a very busy highway. And they were stopped to make a left-hand turn, and it's just it's a two-lane highway. And they were waiting for traffic to clear. Behind it was a Cable One Ford F-150 utility truck. As the driver of the utility truck topped the hill, it had a quarter of a mile of clear visibility, and the driver had his cruise control set on 71 miles per hour. It never stopped. It hit the Ragsdale Woodson vehicle at 71 miles per hour. It thrust him into the path of an oncoming vehicle that hit him at 62 miles per hour. And Mindy and Peggy were instantly killed. Amazingly, Mindy's son, 3-year-old Cody, was in a car seat. Maybe the greatest car seat that's ever been designed, ladies and gentlemen. Because that poor baby withstood 2 terrible impacts, and all he had was a broken ankle. The collision killed 30-year-old Mindy Ragsdale. Mindy was a stay-at-home mother of 3-year-old Cody, 9-year-old Austin. Her husband of 11 years, Jeremy, that took her to the senior high prom, was left to raise his children without what I truly believe to be one of the greatest mothers in the world. The collision also killed Mindy's 82-year-old grandmother, Peggy Woodson. Her husband of 62 years, 87-year-old Orville Woodson, was cared for her in the home. And within weeks of her death, he had to go to the nursing home where he will spend the rest of his days being cared for there instead of by his loving mate. In the immediate aftermath of the collision, an EMS worker asked the Cable One driver what happened. And he said, "I was texting prior to the wreck." In connection with the filing of that lawsuit, we hired Dr. David Strayer. And Dr. Strayer looked at all the evidence and everything else, and he said, indeed, this was a classic example of driving while distracted, due to the texting causing inattention blindness and the lack of situational awareness. This man did not see what was in front of him, with very tragic consequences. Cable One is the 10th largest cable company in the country, and it's owned by the Washington Post. You would have expected it to have known better and to have done better. In a moment, you'll see that Cable One had a lip service discretionary policy with no clear boundaries, no real understanding from top to bottom as to what their policy was, and absolutely no treatment of texting. You're also going to see the fact that even their own expert, Dr. Richard Hanowski with the Virginia Tech Transportation Institute, was forced to admit their policies were inadequate and that this driver was a dangerously distracted driver. I prepared a short 8-minute clip of the testimony we collected over literally dozens of hours of depositions to play at the mediation of the Ragsdale case, to show them indeed just a little bit of a flavor of what the jury will see. And I want you, if you indeed are involved in any kind of company decision makers, to put yourself in the shoes of these drivers, of these people, and see what you would say. And I'm asking you, you never saw the Woodson white vehicle before you hit them?
I don't remember seeing them.
All right. Not down the road, not ever? Is that a yes?
No. I mean, yes, that's correct.
If the evidence in this case establishes that you have 15 seconds or more of clear vision of the roadway ahead of you before the actual place of this collision where the Woodson vehicle was traveling, you have no explanation for why you never saw them.
I don't know.
What did you see when you got to the scene?
Pretty horrific scene. I mean, it was, vehicles and damaged, and I mean, it was not a pretty sight. I had EMS people and fire department and police there.
What were you told?
I was told that basically Davian told them that either he had been on his cell phone or he was texting before the accident, and that's what they said he had told to them.
The policy dated November 3rd did not prohibit the use of cell phones or any other communication, but told associates that they need to be aware of it. They need to follow state and city, legislation, follow the laws, and to make every effort to not be distracted with radios, pagers, mobile communications, and basically to try to pull off the road whenever it's possible and whenever it's safe.
What was Cable One's corporate policy regarding texting while driving on January 25th, 2010?
It would be the same as this policy, to not be distracted, to make every effort to not do things that distract you from the road, and to follow the state laws and local laws.
Have you ever seen a single piece of paper from Cable One addressing texting while driving prior to January 25th, 2010?
Not that I recall.
You would agree with me that then a cell phone exposes the public, cell phone use while driving exposes the public to unnecessary risk of an accident.
In some cases, yes.
Okay. What cases doesn't it expose the public to a risk?
I think if you're case by case, once again, nobody around and you're stopped and pulled over and in your vehicle, using your best judgment.
Okay. As Director of Safety, do you believe that texting while driving company vehicles involves an extreme degree of risk to the public?
I think that it's very dangerous.
Okay. Are there any formal written policies at all from Cable One that specifically address texting while driving?
Not that I know of.
My policy is that if you're going to use a cell phone, that you should use it in a manner that's safe, that you should use it in a manner that doesn't cause a problem, and use it in a manner that doesn't cause accidents.
Okay. How do you use a cell phone in a manner that doesn't cause accidents?
I don't know.
When David Bennett was hired on May 1st, 2008, what was Cable One's policy regarding cell phone use while driving company vehicles by your field techs?
Well, it was, that we're not supposed to use cell phones while they drove. Just standard,
What did you understand the Cable One policy to be?
As far as cell phone,
Yes, sir.
if you were going to be using cell phone, please be hands-free and to minimize your talk time if you were going to be using it.
So they did not prohibit you from using your cell phone?
You can't prohibit it because even the lead techs, they have company phones that people call them on.
You would agree with me that Cable One has the authority to completely ban cell phone use while driving company vehicles?
We could.
You would agree with me that if Cable One banned the use of cell phones while driving company vehicles, that would eliminate the potential danger posed by cell phone use while driving?
If we wanted to eliminate cell phones so that people who are distracted, who are using them improperly, are safer, yes.
You would agree with me that your policy, as it currently reads, gives your associates the discretion to determine when it is safe to use a cell phone?
Yes.
And your studies, as we've just gone over, your recommendations as a result of your studies are that cell phone use while driving should be banned.
Correct.
It's your understanding that these policies, as written, provide Cable One drivers with the discretion to determine whether or not it's okay to use their cell phone or to text. Is that correct?
To use their discretion, yes, correct.
This is a discretionary policy.
Yes.
This is not the kind of policy you would have written had you been writing a policy like this.
I haven't written a policy, but based on my recommendations, that's correct.
You would have specifically addressed it texting and specifically banned it, correct?
Correct. Yes.
So do you believe it's an inadequate policy?
Yes.
There's no question at all that Davian Bennett was a distracted driver, correct?
That's my opinion.
It is also your opinion that a period of 14 seconds, you understand that he had a period of 14 seconds when the Woodson Ragsdale vehicle was potentially visible to him.
Potentially, yes.
For you as a scientist and for you somebody who has studied people being distracted from the roadway, 14 seconds would be a number that is almost inconceivable to you, correct?
That's correct.
So we don't think that's respectful to our associates or reasonable in this day and age to ban communications. We trust our associates to have really great judgment, and that's what these policies are about, and I think that we have done that.
If the evidence in this case establishes that Davian Bennett was texting before this collision, in other words, that it contributed to this collision, would you agree that he used good judgment?
I would be surprised. I've never heard of any of our associates texting and driving. I think texting and driving is a bad decision.
In light of the deaths of Mindy Ragsdale and Peggy Woodson, do you wish you had done anything differently with regard to your cell phone policy?
No.
So there's really only one response to this problem that makes business sense. Because without a ban, the employer loses either way. Let me tell you the box that I put you in, ladies and gentlemen. You saw it. You can either admit you didn't recognize the problem, which is just ridiculous in the light of the storm of media attention and in light of the juror's own experience. But if that's what you say, then I get to ask the jury to educate you. Or you could admit that you knew about the problem, but you didn't take effective and decisive action. That's my favorite position, as you saw. Because indeed, I can prove in that instance that you knew better, but you didn't do better. And I will ask the jury to teach you and other companies like you a lesson. So how's the only way an employer can protect itself? And that's going to segue nicely into Dan's speech. But I will tell you that there is only one defense to these kinds of cases, and the only one way to protect your company from this kind of exposure, and that's to have a clear-cut, non-discretionary policy. The policy must unequivocally ban all cell phone use, including hands-free, while on the job. It must be accompanied by employee education and management buy-in. It has to apply across the board. It must also be enforced. It must be enforced through constant reinforcement of the message, monitoring, technology, progressive and publicized penalties for violation. And if you're still wondering if that's the right choice for your business, put yourselves in the shoes of that national safety director. Put yourselves in the shoes of someone being asked the question, in light of the serious injuries or death of a victim, do you wish your company had done anything different with regard to your cell phone policy? Dan?